Good afternoon, everyone, and welcome to the webinar, Witness Intimidation Part 1, Enhancing Witness Safety, Preventing and Responding to Intimidation. Today's program is presented by Equitas. My name is Cynthia Hatchell. I'm the project coordinator at Equitas, and I will be moderating today's webinar. If you have a question during the presentation, please enter it in the chat box to your right. We will answer questions at the end of the webinar. You are also welcome to contact us directly at any time following today's presentation, and we will send you contact information during our follow-up. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. You can also follow Equitas on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Next slide. Today's webinar is supported by the U.S. Department of Justice Bureau of Justice Assistance. The information presented in this webinar does not necessarily reflect the views of the Bureau of Justice Assistance. Next slide. Presenting our webinar today is the Executive Director of Prosecutors Center for Excellence, Christine Hammond. Christine Hammond is the Executive Director and founder of Prosecutors Center for Excellence. PCE conducts assessments of prosecutor offices and provides consulting services to promote innovative best practices and implement solutions. PCE supports statewide prosecutor-led best practices committees that have formed in 20 states. PCE publishes articles on a wide variety of criminal justice issues and hosts regular national meetings for prosecutors. From 2013 to 2016, Christine Hammond was a visiting fellow at DOJ Bureau of Justice Assistance. Before that, she served for 3 decades in the Manhattan District Attorney's Office in New York City, where she was on the executive staff. She chairs the New York State Best Practices Committees for Prosecutors, teaches at Georgetown Law School, is on the ABA Criminal Justice Journal editorial board. Ms. Hammond has received several awards for her public service. I will now turn it over to Christine Hammond.
Thank you, Cynthia. Welcome everyone to the webinar. The topic of today is to discuss witness intimidation and various approaches that prosecutors can take to reduce intimidation and increase witness cooperation. We'll start with a very basic question, which is, what is witness intimidation? And I'm sure for anyone who's a prosecutor, this continuum of consequences of witness intimidation is well known to everyone, but it's worth going through. One aspect of intimidation will cause a witness never to come forward, so you won't even know that they exist. Even if you do know they exist, they may refuse to cooperate. Even if a witness has come in and is cooperating, they may stop cooperating and refuse to testify. Some come in and testify, but they may testify falsely. Others who've testified accurately may then subsequently recant. And finally, the worst result of all is the injury or death of a witness. But every one of these factors is influenced by witness intimidation. And we are going to discuss today various things that prosecutors can take to try and minimize the impact of witness intimidation on our cases. Intimidation of witnesses has moved online, as everything else has, And so here is just an example of a Facebook page where a face was put in a wanted ad because he had cooperated. Um, Here is a tweet where redacted police paperwork was tweeted along with the name of a witness so that people know that this person was cooperating with the police. We've seen videos that reveal that. We've seen videos of witnesses being beaten up as a result of participating in a criminal trial. And needless to say, all you have to do is see that once, and it's easy to be deterred. But as prosecutors, we can't just give up and say people are not going to cooperate. We do have to work and try and see what we can do in order to make people feel comfortable coming forward. And there is no one answer to this. You have to work every angle. So, of course, working with victim witness advocates is essential. They are the front line of this effort to try and get our witnesses and victims feeling comfortable enough to come forward. We also have to investigate claims of intimidation. We must have, as prosecutors, legal strategies to protect our witnesses as best we can. The courts have to help us. This cannot be done by the prosecutor alone. And the community also has to be part of the solution in getting people to come forward and testify on behalf of our cases. So all of these things require different strategies, and none of just one of these can accomplish the goal. So there are some basic principles to dealing with victims and witnesses, is that, and I'm going to talk about this in greater detail, is that you need coordination of all the players, police, advocates, community, coordination from the moment of the crime scene all the way through trial and after trial as to what services and what message is being conveyed to victims and witnesses. We should talk to our victims and witnesses in a trauma-informed way. We should be culturally aware of who our victims and witnesses are so that we treat them with the respect that their culture expects. We should stay in touch with them on every case. And we should do the best we can to help the victims where they need it, as opposed to them always having to come to us for help. We can go to them. So these are just basic principles that underlie every aspect of our approach to victims and witnesses. Now, I want to sort of overlay this lecture with considerations about the virus, and I will just discuss those issues as we move along. But we all know, and from reading articles and from our own experience, that this has had a devastating effect on the criminal justice system and on our victims and witnesses. We've heard, of course, of the fears we have about increased domestic violence, increased child abuse, increased elder abuse, all the kind of abuse that can go on behind closed doors when there's nobody watching. The other concerns are that many of the services and resources available to victims and witnesses may be shut down or operating in a different way. So I will discuss various aspects of this as we move through the presentation. So we're going to go chronologically through a case and how police and prosecutors interact with victims and witnesses. And I think for just to keep it easy, I'm just going to refer to everyone as witnesses as opposed to victims and witnesses. But we're going to start at the beginning, start at the crime scene, and work our way through the trial. And each aspect has its own challenges. So needless to say, the first place that a witness is met is at the crime scene. And the most likely person to meet that victim or witness is a police officer. This photograph is a little unrealistic because often our witnesses don't point fingers right then and there, and officers usually find them in a more quiet corner, but it is the officer who usually identifies who that witness is. That officer can begin the process of doing a risk assessment. um, this tattoo. It's a little cut off in this slide, but this person has a "Kill All Rats" tattoo on his back. So that shows you how powerful that ethic is in some populations. Um, but in any case, early on, from the very first step, the police officer and a prosecutor should do a risk assessment. I think we do this sort of automatically, but it is useful to do it in a more organized fashion. Domestic violence victim advocates often have lethality assessments that assist with that, but lethality assessments can be used for all kinds of cases. So, for example, gang cases where people are living close to each other that are either in a similar gang that where someone may be cooperating against the other, or living near the opposing gang. We know that is a risk. Domestic violence is a known risk. There are other factors that can be a risk. Just living close to one another, being friends or family of someone who is being accused. All of these are risk assessments. None of these are guarantees. We have seen terrible witness intimidation in white collar cases, in cases where you would never expect it. But at least everyone should be mindful from the very beginning. What is it that your witness is facing, and how closely should we be watching what's going on with that witness from the very beginning? So the first person to meet with a victim, a witness, um, used to be victim advocates from the prosecutor's office, but this is now changing. Many police departments have victim advocates as well, and they may be the first person to meet with your victim. Um, it's important for the prosecutor's office to coordinate with the police department victim advocate so that the prosecutor victim advocate and the police department victim advocate are on the same page. Are they making similar referrals? Is information gathered by the police advocate handed over to the prosecution advocate? So right there is a need for coordination that often does not exist. Many prosecutors' offices may not be aware that there is an advocate at the police department. But in any case, the advocate for the prosecutor needs to get basic information about the witness. Again, this is common sense, but it should be a broad question, not just what is your name, address, and phone number. It's useful, of course, to get an email address, but a interesting and useful question for witnesses is, how do you communicate? Because some witnesses communicate through WhatsApp or Facebook or other less traditional methods of communication. The advocate should be asked to find out those other means of communication so that they can stay in touch down the road when they need the witness. Obviously, questions should be asked about what social services are needed. There should be some discussion about a safety plan. Is the witness concerned about their safety? Are they using social media safely? Often witnesses don't realize that if they put on their Facebook or on Instagram that they've been to the DA's office, that may be a challenge. So, the other person that can be extremely helpful to a victim advocate, who is often a non-lawyer, sometimes a social worker, occasionally a clinician that can actually provide some counseling. But another member of the team that's very helpful is to have an actual investigator, someone with police experience, a law enforcement person who can assist with safety planning, relocation, and dealing with threats. So having a police officer in your, or a retired police officer who's on your staff to participate in this is often not done, but is helpful because they have a much better ability to assess threats and to provide assistance in how to deal with the threats. So, and finally, when the prosecutor meets, again, you want to ask about this, the contact information and how to stay in touch. All of this information that's gathered by the police advocate, the prosecutor advocate, the investigator, and the prosecutor should be put in one place so that if the prosecutor, let's say, leaves the office and someone else comes in, that all of the contact information is kept in one place. Every contact with the witness should be maintained in the case management system, if there is such a thing, but you need to gather all of the contact information. It's not uncommon for the victim advocate to have contact information that the prosecutor does not have. It's worth doing a little assessment of whether your office has a coherent process for collecting all of that contact information. And of course, everyone realizes how important that contact information is when it comes time for trial, and now you can no longer find your witness. And it may in fact be that there are others in the office who have that information. So putting it into your case management system, also creating a flag in your case management system or some method for identifying the high risk cases, so that if from the beginning you've done an assessment and realize that this person is at risk, everyone in the office should be aware of that. And there should be a way to flag that for all members of the office, whether it's a paralegal or any other person who is handling that case. They should quickly see that this is a case where someone has a concern about possible risk for that witness. And there should be a way to identify that. So before we get to relocation, it's worth just talking about the current environment. Right now, most people are working from home. Victim advocates are working from home, and witnesses are often trapped in their homes. We have seen tremendous work by prosecutor victim advocates in this new world, where they have been reaching out to their victims on a regular basis to see how they're doing. Now, that is a little bit of a balance. In some instances, I've heard from victim advocates that they're afraid to call too often for potential fear of angering a potential abuser that may be in the home, and yet they do want to find ways to stay in touch. So in this world where it's not easy to have someone come into the office because your office is closed, there are other solutions. The more high-tech solutions that are being developed are various apps that some prosecutors are developing and some groups are developing to allow a witness to indicate some concerns that they have remotely, and that these apps feed into either a call center or a place that can easily provide assistance, or at least try to provide assistance. But an app is a technological thing that's harder to develop. What's more likely to happen is that your victim advocates are reaching out through old-fashioned methods, email, phones, Facebook, to see how people are doing, and to see if they can provide some services. Now, of course, that raises a second issue, which is which services are actually available. And your victim advocates should be doing an overview of what services are available in your jurisdiction now. Is your homeless shelter open? Are there drug treatment centers available? Are there places to drop off children if your witness needs it in order to participate in something you need them to do at the courthouse or in your office, assuming they're open? Are there social services that can provide help with housing and other issues that may face a witness? Many of these services may now be closed. So your witness advocates don't want to be in a position where they're recommending to a witness to go or at least call someplace that may in fact not be open. Relocation is an option that's often not available to some offices because it's too expensive, and it's probably not particularly available now when people are not allowed to move around. So hopefully one day we can come back and talk more about relocation, but it seems somewhat moot right at the moment. The key to all of this, whether there's a pandemic or not, is to stay in touch. It's not uncommon for prosecutors to meet a witness or talk to a witness at the beginning of a case when they're charging, and then 2 years later call them back when they need them for trial. That should not be the way prosecutors have a relationship with their witness. There should be a constant, regular outreach to the witness, even if it's simply to say, nothing's happened in the case, it's been put over for another month, we'll see what happens, just to give a status report. Obviously, victim advocates can help with that outreach, but I would recommend that the prosecutor, him or herself, do that on occasion themselves. If in fact there is intimidation, so this is another prong of this, that should be investigated vigorously. And there are many investigative avenues for that: jail calls, surveillance, all of the kinds of things that we would do to investigate some violent crime. Again, this is much harder in the current environment. The police are very restricted in what they're doing, but work can be done from home, where jail calls can be reviewed, social media can be reviewed, cases can be investigated remotely. But of course, it is harder to go out and get surveillance videos and things like that in this current environment. Once there is a witness intimidation charge, that should be prosecuted with a very high priority. We do make reference here to putting the case in the grand jury, but so many have no grand juries right at the moment. So again, that's a moot issue right at the moment. But once the case moves forward with a charge, and there is a real concern about a risk to a witness, needless to say, there are legal strategies. Higher bail can be requested, an order of protection can be requested. You could even submit, in some jurisdictions, charging documents without mentioning the name of the witness. Now, high bail in this environment is also difficult. There's a real pressure on courts and jails and prisons to release people because of the pandemic. The more information you can gather about risks to the witness, the better. Because if you feel, in fact, that they are at risk of physical harm, obviously an argument for bail should be made despite the virus. So lately, preliminary hearings have been going on in some jurisdictions via Zoom or other kinds of applications. And this is an example of an application of a hearing that takes place remotely, with all the players remotely, and the witness and evidence can be taken remotely. This is a new world. This is probably something that is here to stay in some form or another, where there will be remote hearings. But there are significant issues around this involving witness safety. In New York, they've just extended I'm a New York lawyer. They've extended various statutes in New York to allow for remote preliminary hearings, but the governor's extension allows us to obscure the face of the witness. So we do have some options that upon request, we can obscure the face of the witness in this kind of remote proceeding. That's particularly important because in some states, they're posting these remote proceedings on YouTube. So for example, in Michigan, remote proceedings are posted on YouTube. And though there is a right to the public to see these proceedings, you want to make sure that your witness is not jeopardized by being posted on YouTube. So there are many lessons to be learned from this. We're only just beginning to understand what the legal issues are. We're trying to figure out the technology, which is complicated, but this is where prosecutors are being pushed into having remote proceedings where witnesses may have to participate. So discovery is another area where witnesses can be put at risk, where information about how they can be found and so forth can be revealed. So again, some states are more lenient on this than others, but prosecutors need to take some legal steps when they are concerned about the safety of their witnesses to redact all numbers of things, redact arrest reports and police reports, redact search warrant affidavits, redact photographs and videos. So for example, a body-worn camera can easily be recording a police officer asking a witness what their address is or what their phone number is. These are things that need to be redacted. In some instances, if it's really serious and it's hard to redact, some discovery can also be delayed. And in other instances, a protective order can be sought that would allow only the defense attorney to see the discovery and not the defendant. Some have argued that in these remote preliminary hearings, if a witness is called where there's a risk, that some prosecutors may try to make a similar argument for the preliminary hearing, that the judge can see the witness, the defense attorney can see the witness, but not the defendant. So these are things that we are still exploring in this new remote world.
We have a question.
Yes.
Can you name some jurisdictions that allow charging documentation without the witness's name?
Yes, New York. Yes. In New York, in our charging documents, we can say a name known to the district attorney's office. So is there another question? Or not, I'll just keep going. Here's an example of what can be done. This is an example from Pennsylvania where they have gotten a protective order so that the information can only be given to the defense attorney and shown to the defendant, but not given, the defendant cannot keep it. This stopped a practice where defendants were spreading discovery around and endangering witnesses. This was proven to be very helpful in protecting witnesses, to have this kind of watermark placed over discovery. One thing to think about, though, in redacting and protecting witnesses is we still do have Brady and Giglio obligations, so we do have to remember to turn over witnesses' inconsistent statements. People often have gotten in trouble or have sometimes gotten in trouble by forgetting to turn over benefits that they've given to witnesses, such as putting them up in a hotel overnight during a trial or giving them transportation money, things that seem pretty de minimis, yet they do have to be turned over as Brady and Giglio material, at least in most jurisdictions would deem it that way. So once you get to a hearing and trial, I think it is useful to make sure that your judge has a sense of responsibility for the safety of your witness. And judges are often kind of hands-off when it comes to that. Pennsylvania had a very big witness intimidation problem that was revealed in a series of newspaper articles that then triggered the development of a bench book for judges. And this bench book for judges that was written by a collaboration of criminal justice partners provided information to judges about how they themselves can protect witnesses in the courtroom. The introduction to that bench book reads as follows, and it puts notice on the court that they have a responsibility. So I'll just read it quickly. Judges stand as guardians of the courthouse, the place where wrongs will be redressed without fear or recrimination. It is the responsibility of the court to create an environment in which truth can be spoken. And that bench book that we can distribute a copy of has been updated and is used by courts to understand how they can control their courtroom to make sure it's safe for their witnesses.
We have another question.
Yes.
Can you provide a list of what information can be redacted?
That is, I think, entirely dependent on your local statutes. In New York, which where I'm most familiar, that list has recently been governed by statute. So it is unfortunately a case-by-case analysis, but one would hope that even if it's not in your statute, through a protective order, you can seek to redact large amounts of information that would reveal someone's where they live, how to get in touch with them if they are at risk. But I would consult your statutes for a process. In any case, it's useful for prosecutors to try and meet with the courts and see what the courts are doing to put them on notice that they have some responsibility here. So one thing to think about is that there are these different things that can be done during the course of the trial, and in part 2 of our webinar, more of this will be discussed as to how you can introduce prior acts of intimidation, forfeiture by wrongdoing, and things like that. But, and all of that you can start lining up through motions of in limine before the trial begins so that you can get the judge's agreement on these matters before things get out of control. And one of the things, aside from evidentiary issues that you can ask, is how is the judge going to control the courtroom? Can the courtroom be closed to certain people or certain things? For example, can you keep out cell phones? Can you ask for someone's identification before they come into the courtroom? These are all issues that can be resolved in advance. So courthouse security is another thing that is worth knowing about, because this is it's a little hard to tell, but these are 2 court officers who are wrestling an unruly defendant. But there should be in every courthouse courtroom security protocols for what should happen if there is something going on in the courthouse that is unsafe, or if there is a high-profile trial or a trial that could raise some issues. And the prosecutor should figure out who is in charge of that at the courthouse. Find out who they are. How can they help you? What are their rules? Can you ask them to keep out cell phones? Can you have your officers in the courtroom to assist and make your witnesses feel comfortable? Will your judge make announcements in the courtroom about courtroom behavior and so forth? These special court officers can be your friend. They can help you when you take a case to trial, because of course the trial is the flashpoint for intimidation, because that's when the rubber meets the road. If the witness doesn't appear at trial, the case is over. And that is often when things start to go sideways. So it's useful to know all of these things in advance so you're not scrambling as you're about to try your case and have a million other things to think about, and now suddenly you have to think about courtroom security. Another question to think about and look at is, what is it like to walk into your courthouse if you're a witness? One day when you're walking into your courthouse, if you ever get back in, which hopefully they'll open up at some point, walk in and say to yourself, this is the first time I've ever been in this building. What does it look like? What does it feel like? Who else is standing around? Could it be that people who are just there for other cases may be a risk to your witness? How can you get your witnesses into the courthouse in a way that is less threatening? Is there another door that they can get in as opposed to going in through the general public? Should you meet them outside and bring them up? Put yourself in the shoes of a witness who's never been to a courthouse before. That alone is scary and daunting, and useful for you to have a sense of how that works. Courthouses should have, in addition to the trial, the courtroom where the trial is happening. I've been in courthouses where victims, defendants' families are all put in the same place, all in the same waiting room. This is hotbeds for problems and intimidation. Don't forget that there are surveillance cameras often around your courthouse where you can actually get film and see what's going on. You may actually uncover intimidation that's going on right there in the courthouse, which is a likely place for it to be when a trial is pending. Another thing that is can easily be forgotten is, in a high-profile case, press may be in the courtroom, and press may actually know the names of some of your witnesses that you're trying so desperately to hide from the defense. And the press, we have seen, have sometimes published the name of this witness in their news story when you've been trying to keep it quiet through a protective order. So it's worth making sure that you're in touch with the press if they're there, so they understand your security concerns, so that information is not leaked out that way inadvertently.
We have questions.
Yes. Yep.
Can you talk to the process New York took in getting to remote hearings? For example, who proposed the idea and to whom, and how quickly it was implemented?
So we're not there yet. We've only gotten notice within the past few days that this is going to begin. New York's system is different from most of the country, because we are not allowed to have hearsay in our preliminary hearings. So that means that we have to bring our actual witnesses to a hearing. So this is all under discussion right at the moment, and we're trying to figure it out. The courts don't know what they want to do, and we're waiting to hear from them. However, other jurisdictions are doing this. So in California, in San Diego, for example, they have been doing remote preliminary hearings for a while. They do not require hearsay at the preliminary hearing. And so far, it has been relatively successful, and they're doing more and more of it. And if anyone is interested, San Diego has written a guide on how to conduct a preliminary hearing remotely.
Can you talk about the process that New York used to get approval for redaction and who was involved in this process?
As I mentioned, we have a new discovery statute, and that statute governs what we are allowed to redact. Unfortunately, the prosecutors were not particularly consulted when they drafted the legislation. So just continuing, the witness preparation. Another thing to think about is to make sure that the witness is familiar with where they're going in the courthouse and how you're going to get them to and from. And so they're not upset or rattled simply by the unfamiliarity of where they're going and where they'll be sitting. So what I would recommend from all of this is there is much more to the many different facets of what it takes to protect a witness than we'd previously thought about. All of these things, from legal strategies, courtroom security, relocation, social services, are all almost its own specialty. And I would recommend designating someone in every prosecutor's office, a lawyer, who is familiar with all of those things, so that if someone in the office is suddenly confronted with a witness intimidation issue, which happens unexpectedly on a Friday afternoon when nobody's around, nobody knows what to do, it is useful to know who can be called in the office, not just the victim advocate, but someone who has the legal strategies for how to deal with intimidated witnesses. And that can also include witnesses who are in custody. cooperating witnesses who are in custody. That's a whole nother issue, is how do you protect witnesses who are in custody? So that's number one recommendation. Make someone an expert in your office to study all of the things that I've mentioned. Secondly, have training for your office. Do your prosecutors know what services are available? Do your prosecutors know what your victim advocates can do and not do? And thirdly, it's useful to designate a prosecutor investigator, someone, a former police officer, to have expertise in protecting witnesses. It is also important to have cultural competence and understanding. There's been a lot of discussion about implicit bias of prosecutors and defendants, but the same can occur between prosecutors, victims, and witnesses. Prosecutors have to have an understanding and a cultural competence of the populations that they serve and the people that they serve, and it makes conversations with your witnesses and victims so much more respectful and understanding, and you can all be on the same page if there's more cultural competence and understanding. Finally, this is a huge area that is almost a topic for a webinar in and of itself, is reaching out to the community. It's the community that you're trying to keep safe. They can help in so many ways to provide support for your witnesses, to help you bring them in, to provide support when you're not around, because 99% of the time you're not around. You can work with community groups, religious institutions, about coming up with a communication strategy to make people feel comfortable about coming forward. You can host a witness intimidation forum and bring in stakeholders and community members and have a community discussion about this topic. Everybody wants to live in a safe community, and we all know we need witnesses in order to help us reach that goal. And working with your community that will benefit from this will result in many gains going forward, and friends, and help when you need it, when things are really difficult in a case. There are also other groups. There's one in Kansas City that, as an example, called Mothers in Charge. They're groups that are mothers whose children are the victims of gun violence, who often can serve as a bridge between the community and law enforcement, can help. They're groups, local community groups that respond to every homicide scene and provide assistance to the people there, and can help explain law enforcement to them. There have been initiatives where cops and prosecutors have trained religious leaders in what happens at homicide scenes, how they're investigated, what they need, so that religious leaders can help with this. This is a long standing issue that should continue. It inures to the benefit of everyone, and one of the benefits is to keep our witnesses and victims safe. So all of this requires coordination. This is a group that would be great for victim forum, victim safety forum, where you bring together courts, police, hospital emergency rooms is another area, flashpoint where there could be danger, social services and community groups. Prosecutors are natural leaders, and prosecutors can convene a meeting, can convene a task force of these groups to discuss how to improve how we assist our victims and witnesses. And a lot can be done here in terms of coordination, where everyone's working together. One office I've seen has actually done a survey where their victim advocates do a survey. They ask the victims and witnesses who come in, how do you think we did? Did we help you? Is there more we can do? And people normally don't like surveys, but some prosecutor offices have used interns to help follow up and ask the survey. And it's always good to get some feedback and learn how you can do better. So that brings us to a close. This was a very high level 10,000-foot view of the things that could be done, but it shows there are many pieces of this puzzle, and they all need to be work in coordination. I hope all of you are healthy and you stay safe. Many of the things that we're learning today, we will keep. It may be that the outreach that we do to victims and witnesses this way is something that they like. People may not have to take time off from work the same way, or they might not have the same childcare issues. So there are lessons to be learned from these very difficult times. So I hope you all are well. If you need any resources about this issue, Prosecutor Center for Excellence's website has resources. We send out articles of interest with virus-related articles and other policy articles, and I'm open for any questions, should there be any.
Okay, we do have a few.
Sure.
The first is, given that courtrooms are open to the public, what is the process of closing the courtroom for sensitive cases?
Again, that is a statutory process. In New York, we can close the courtroom for certain people like undercover officers, but that requires a judicial finding that the officer is in danger and the courtroom is closed. Sometimes they will close the courtroom to the general public, but not the family of the defendant. There are variations on it, but arguments can be made to close a courtroom through a protective order, but again, it depends on the limitations of your local statutes.
What is the best way to motivate a prosecutor that does not prepare for court?
Oh, that's an interesting question. That's a whole nother question. Sometimes you would think adrenaline should be a sufficient motivator. I suppose that goes to improving supervision and having someone sit down with them and go through their case and make sure they're ready.
With the virtual preliminary hearings about to start in New York, we have a concern with witnesses testifying from a remote location because we have no control over potential outside influence and threats. Anyone have a good idea on this?
Well, I can tell you things that are being contemplated in New York, and again, we have not solidified this yet, but some offices are thinking about creating a room in the DA's office, hopefully like on the first floor, where a witness can come in. The room will be cleaned before the witness comes in, and the prosecutor will be in that room as well, and but 6 feet away from the witness, and the prosecutor and witness will be in the room together during the preliminary hearing. And then when the witness leaves and the prosecutor is done, someone comes in and re-cleans the room, awaiting the next witness to show up.
Do you have any contact in San Diego as to how they do remote preliminary hearings from a logistics perspective?
Yes, I'd be happy to share their guide. Yes, I have a guide on how they do it.
Thanks so much, Chris Hammond, and thank you all for participating in today's webinar. A recording of the PowerPoint presentation as well as a PDF handout will be sent via email following the webinar.
Thank you, and stay safe.